In February of 2007, the First Nations Child and Family Caring Society and the Assembly of First Nations filed a human rights complaint, alleging that the federal government's provision of First Nations Child and Family Services on reserve and in the Yukon Territory was flawed, inequitable, and thus discriminatory under the Canadian Human Rights Act. The federal government funds First Nations Child and Family Services on reserve and in the Yukon Territory through the Department of Indigenous and Northern Affairs.
The case is about equality, really at its core. It's about human rights and respecting the dignity and equality rights of First Nations kids. That's really what it's about. It started because the government refused to treat these kids equally. They had been at the table for 10 years to try to get on-reserve funding for child welfare services to be comparable at the very least for on-reserve kids, and the government refused. So that's really how the case started, was trying to bring these issues to the forefront to get the government to fund on-reserve child welfare equally, and at the same time also respect and implement Jordan's principle, which they were also not doing at the time the case was launched.
After study after study, and after a long series of recommendations from very intelligent and very well-resourced people saying that in fact there's a lot of inequity here. There's underfunding on reserve. It's something like 67 or 70 cents on the dollar to what a non-First Nations kid would get in terms of child and family services, when the needs are actually probably for more, for $1.25, $1.30, $1.50 on the dollar, because of the historic circumstances that kids living on reserve face. And so that's why this case was brought, and that's what it's about, is ensuring that those kids have equal opportunities at the end of the day to make the life they want to make for themselves. And that's what the Canadian Human Rights Act and non-discrimination is all about.
Dr. Blackstock, she had been working on the issue for decades, the overrepresentation of First Nations children in care. And after trying to work with the government and trying to mediate a solution, she saw that there were no results. And she looked up at a flyer on the Canadian Human Rights Commission on how to file a complaint. It said that you can file complaints on your own, and she drafted with the Assembly of First Nations a human rights complaint against the Government of Canada, alleging that the failure to appropriately fund child welfare services was discriminatory on the basis of race and ethnicity.
The complaint further alleged that the federal government had failed to implement Jordan's principle, a child first principle passed unanimously in the House of Commons in 2007 to ensure First Nations children can access public services without denial, delay, or disruption.
The federal government is, in theory, responsible for all services to the Indigenous population. And provincial governments are responsible, in theory, for services to the rest of the population, but they don't agree on exactly where the line lies. Then you're bound to have a number of disputes between them. People from federal and provincial services saying, oh no, that's not us, that's them, and playing ping pong with Indigenous children, in a sense. I think when you think about it, it is also a matter of equality. Because when Indigenous children are sent from one government department to the other, to one level of government to the other, it's something that non-Indigenous children would not suffer. They would have a clear gateway for those services. So having to face these jurisdictional conflicts is something that is peculiar to Indigenous children because they're Indigenous. So it is discrimination. And Jordan's principle is a way to fight discrimination.
So Jordan's principle is named after Jordan River Anderson of Norway House Cree Nation in Manitoba. He was a little guy born with some pretty complicated medical needs. And so when he was first born, he had to stay in the hospital to deal with all of his complex medical needs. And after a couple of years, the doctor said, okay, Jordan, you can move from a hospital setting, which isn't really a fun place to grow up, into a residential setting. But the federal government refused to pay for the transfer, the equipment, the medications that he needed, and so did the province. It also said, well, he's a status Indian, that's the responsibility of the federal government, and the federal government said healthcare is a provincial responsibility, he's your responsibility. And so for years, the federal and provincial governments fought about who should pay for Jordan's care, and he eventually died in hospital at age 5, never having left. So Jordan's principle says that we should put the child first. The government of first contact should provide the service to the child that they would automatically be getting if they were not a First Nations child. And you guys can fight about it later. That's the principle. Now we are getting closer to an actualization of that principle in how First Nations families are being treated. The way to get help is to contact Health Canada or to contact your provincial health counterpart. Say what the service is that you need, it should be provided to you, and if it's not, then you can either call us or there are other navigators that can help you in the system.
The federal government spent 6 years and over $3 million trying to get the complaint dismissed on legal technicalities. Their attempts were unsuccessful. Hearings before the Canadian Human Rights Tribunal began in February 2013 and concluded in October 2014. On January 26, 2016, the Canadian Human Rights Tribunal released its decision, substantiating all aspects of the complaint and ordering Canada to immediately cease its discriminatory conduct. The tribunal found that the federal funding formula provides First Nations child and family services agencies with fewer resources than their provincial counterparts. Moreover, the tribunal found that federal funding formulas and policies create a perverse incentive to place First Nations children in foster care and do not address the cultural needs of the children.
It's an honor to stand here with the Assembly of First Nations National Chief. This is a complete victory for children. It strips away any sensibility that First Nations children are being treated fairly by the Government of Canada today. And I want to dedicate this decision to all of the First Nations children who for years and for decades have been denied an equal opportunity to live the life they wish to have had. And sadly, too often were judged by a Canadian public who didn't know any better as if they got more. And I want to dedicate this decision to the thousands of non-Aboriginal children who have written letters to the Prime Ministers over this last 9 years. You see, children may not be experts in politics, but they are experts in love and fairness. And when non-Aboriginal and First Nations children see something that's wrong, they want to do something about it.
The reason the decision is landmark, it's all about ensuring equality of opportunity, equality of outcomes, and so it's not just treating like alike. It's actually about treating people in accordance with their needs and circumstances. And the tribunal was very specific about that where we go at the end of the day. So it's not just a decision about the problems that have existed in the past, but where we're going in the future. Building a new foundation for a First Nations Child and Family Services program, is that it has to be about the First Nations, geographical, historical, and cultural circumstances. And that's really important because First Nations across this country are very diverse. There's over 600 groups, I think, in this country that this decision will affect. And so saying to Canada that you really have to take each of these groups in their own particular context, and there's no one-size-fits-all solution, that's really important.
I would say that this case advances even a new view of equality. I would say it's transformative equality. It's not just about tweaking the service and changing it a bit to take into account the different needs of different groups. It's really about rethinking the way we provide the service and going back to the drawing board. So just as an example of that, the tribunal said that Canada's approach to child welfare services was a lot like putting pillars on a house that had a broken foundation. And they said at some point you need to tear down the house and build a new foundation and a new house. And that I've never seen a tribunal or a court in Canada say that you need to tear down the house, build a new foundation, and start anew. So it's not just about tweaking the system, it's about rethinking completely how it's provided. And I think that's really innovative and transformative.
I think it's a landmark decision because it's the first time in Canada that the principle of equality was used to make gains for the Indigenous peoples. There is this perception that the rights of the Indigenous peoples are more or less an exception to equality. Okay, we have specific services for a specific category of people, and that sounds like something unequal, perhaps, or out of the norm. But in this case, we made, and the tribunal made, the very important point that equality, if you understand it in its substantive dimension, requires special treatment when people are in different circumstances. And here it's quite obvious that Indigenous children are in different circumstances and that they require, first, formal equality, which is services should be funded equally, but also substantive equality, which means that the services should be carefully crafted to respond to their specific needs. And that is something that I think no tribunal or no court had ever said in Canada. Prior to that, we tended to think in terms of Aboriginal rights treaties, special rights, but not in terms of basic human rights applied to the situation of Indigenous peoples. And I think that's the main reason why this case is so special, and it is a landmark.
One of the great things about the decision is that the tribunal really spent the time and energy and effort to review the evidence. The evidence was very dense. It was 70 days of hearings, lots and lots of paper, testimony, transcripts, lots of evidence that came from a lot of different places from across the country. It came from elders, it came from survivors, it came from frontline workers. And so the tribunal actually spent the time to review and discuss all of the evidence in the decision, which is really, I think it's a really tribute to the tribunal because it gives us a pathway to understanding how we got to where we are and where we can go. The other great thing about the decision is it really talks about the legacy of residential school and how that's connected to the present day, which I think when you're dealing with a case in the present, the tendency of the court or the tribunal is to just to deal with the facts on the ground as they are today. But I think the tribunal actually understands that what we're seeing today is linked to the historical inequities and atrocities that we've visited upon our First Nations children. And I think that's one of the reasons it is a landmark decision. The other thing for me as a former social worker that the case makes very clear and says it right out loud is two things. First, that the current funding and the way that we treat our Aboriginal children on reserve is actually forcing them into foster care. It's providing an incentive. It's driving kids into foster care, which I think is a finding that the government can't ignore. And the second thing that the tribunal does says right out loud that the government has known for a very long time that it's doing this and that it was continuing to do it anyway. So for me, those two things are really integral to the decision. As a lawyer, as a mother, as a Canadian, these things we can't look away from.
In November 2016, First Nations Child and Family Caring Society, Assembly of First Nations, Chiefs of Ontario, and the Anishinaabe Aski Nation file motions stating that Canada has failed to comply with the tribunal's ruling and remedial orders.
We found out, sadly, and we were very disappointed that the decision came out in January 2016. It was celebrated all over Canada. Children sent us thank you cards, and they had cake and flowers and balloons, and we had pictures and emails from all these celebrations. And And the government embraced the decision, and we were sad to learn a few months later that actually they had done nothing to respond to the decision. So the budget that was released a few months after the decision was not tweaked to take into account, or tweaked or modified or rethought to take into account the decision. It was a budget that was based on figures and calculations based on discriminatory funding models that the tribunal found to be discriminatory and unlawful. So since that time, we've gone back to the tribunal to try to get more precise orders to really compel the government to do exactly what it's been ordered to do and to cease its discriminatory conduct. And we're really fortunate to have very competent tribunal members who know the facts very well. They've spent over nearly 75 days of hearings, hearing the evidence. They're experts in human rights, and they've been rendering orders to follow up on their initial decision to make sure that the government complies with its legal obligations to cease its discriminatory conduct.
Now I guess we're almost 2 years since the decision, and so there have been more decisions that have happened after the fact, compliance decisions and further more specific decisions from the tribunal about what has to happen.
The tribunal retains jurisdiction over the case to ensure its orders are effectively and meaningfully implemented. At the time of this film, the federal government had spent nearly $9 million in legal fees arguing the case.
I think my best moment personally in the case was when we were at the federal court arguing the right to broadcast the hearing on APTN. It was a really innovative argument. The Canadian Human Rights Tribunal had never allowed camera access. And in support of the APTN's request, we had asked children and elders from all over Canada, Indigenous and non-Indigenous, to provide letters of support on why they were interested in following the proceedings on TV. So we had this beautiful array of voices speaking in support of the APTN's request. And when we got to the federal court, it was at the Supreme Court, actually, argued at the Supreme Court because they were expecting so many people. And it's this big kind of cold building. And all these lawyers were in the room. We were, had our materials. The judge was looking at us. And there are big brown doors that suddenly opened, and kids started walking in. And I don't think the judge had ever seen kids in his courtroom. And first 1, and then 2, and then 3, and 4. And then there were like dozens. and they just kept on walking in. It was like kind of, clowns being put into a car or a phone booth. They just couldn't stop. And then the judge's face had just, was totally frozen. And then the lawyers for the government of Canada also, and turning increasingly red. But the kids just calmly walked in, filled the courtroom, and stayed there for 2 days listening to our arguments. And after, during the break, giving me advice on what I should argue. But that was just such a powerful moment because the whole courtroom stopped. And before we were all into our, procedural issues, and everyone paused and saw these kids walk in who followed the proceedings so diligently for 2 days. And it was a good reminder of why we were there. And that case led to a really important precedent in Canadian law, saying that there should be television access in cases like this where children's rights are involved. So the presence of the kids actually made a difference in the court case, and we're really proud of that.
The one thing that jumps out is this has always been a case that's about kids, and that's something that I think everybody who's been involved in this process has always understood, is that this is a case that's about kids. It's in the first lines of the tribunal's decisions. You've seen it through the hearings at the tribunal with all the kids who have attended in the gallery and watched, and it's not the same kids coming every day. It's been from all kinds of different schools and different groups. And it's really impressive over a decade that there are a lot of kids who have followed this, and now kids who are turning into young adults who are still following and engaged in this case. It's really something that's happened that's outside of just outside of the tribunal hearing room, outside of Ottawa. It's something that has really been followed by kids all over.
I think what stands out for me is the kids. The kids are always there. which is not like any other legal case that I work on or have ever worked on. There's never kids in the courtroom. There are never kids calling in or emailing in or wanting to talk about the case. So there was always kids around, which I found very awesome. Plus our legal team, someone was always pregnant. So many babies were born during the making of this case. So that was pretty cool. I was always feeling like the kids were around.
Well, Spirit Bear, I think, symbolizes the 165,000 children for whom we are arguing this case.
Well, Mamagwe is a Spirit Bear's sister. And so she's an important part of our team, as is Spirit Bear. So it's always nice to have, a reminder with us. Mamagwe or Spirit Bear comes to all of our appearances and sits on the table in front of us, and it's really just a nice part of this case is to have that with us.
I think it was really important to have Spirit Bear and all his brothers and sisters there and the kids there, because it reminded all of us, not just the tribunal or the government lawyers, but all the lawyers and all of the clients, frankly, about why we're doing this case, that we're doing it for the kids. And it's hard as a lawyer and you're getting into the process, even cases about children, they tend to not be in the room. And so you really start talking about them as a number and not as a human being with a spirit and and a life. So having them in the room really grounded all of us, I think, and made it real.
It's really unfathomable that racial discrimination, this blatant, occurs really every day and denies children services like to health and education, services that other Canadians take for granted.
Things have also changed because of all the public pressure there is out there to force the government to comply. And I think that's a very important component of the case, and it wouldn't have happened without that public support, without people asking, why is it that the government is still not in compliance with this decision? So even though it's not it's a little bit different from the usual situation where the court issues an injunction and if you don't comply, then there can be a contempt of court. But the decision and the merits has set a sort of a standard that is now seen by everyone as something that the government has to comply with. And I think that's quite important because it shows how the judicial system can operate in conjunction with public support to bring about change.
Senator Sinclair, when he was the chair of the Truth and Reconciliation Commission, I had the chance to hear him speak at Dalhousie, where I went to law school. And he said this is a situation that's taken us 7 generations to get in, and it's going to take us 7 generations to get out of. And so I think, remembering that as lawyers, we're just one link in that chain, and we're one step in the process in terms of getting to reconciliation and getting to a better, really a better country for everybody, not just for First Nations kids, but for all of us. Because I think when First Nations kids succeed, we all succeed. And so just having that sense of your place in this and what you can do and where things are going to go next is something this case has taught me.
And so we've been working on the case for more than 10 years. So it's been a long, hard journey. I've been working on the case since I was an articling student and off and on throughout my career. So I've learned a lot. I've learned a lot as a lawyer, good strategy, bad strategy. I've learned to trust my instincts sometimes, but also take risks and a way to work around those risks. And I think one thing I've said about Cindy before is that she pushes you as a client to go in directions that you might not normally go because you're used to following a formal process in law. And it's hard to think outside the box sometimes as lawyers in the way that we're trained and the way that we think. But Cindy really, I think she challenged all of us to take risks in the case and push it forward in a way that stayed focused on the kids as opposed to the legal strategy piece, which I think was a huge lesson for me to really think about what am I trying to achieve as opposed to what's the sort of standard process one takes in the law. I've learned that working on a team is really something that I'm so thankful for. I'd never worked on a team we're 4 lawyers now that are working together. Normally lawyers are 1 or 2 when they're working on a case together, and I've learned how to work on a team, and that working on a team actually really is the best way to run a case this big. You really need that many people. We all have different strengths and different weaknesses, and we are able to marshal those together, which has been such a gift. And I have learned that the racism is much worse than I thought. I think that's been my biggest lesson. I think I really came up through this case thinking the whole way along, once we get the evidence in, once we take this next step, once this witness is cross-examined, Canada will do the right thing. And I have continuously been surprised that they're not, and I continue to be reminded of that every step we take. It's so difficult. Everything is marred in bureaucracy and explanations and justifications, but no real answer has ever been given as to why the discrimination continues. And I have now come to the conclusion that it is rooted in racism, and I really wasn't expecting that.